All right. Well, good evening, everyone, and welcome to our seminar on the importance of living trusts. My name, for those who don't know me, my name is Catalina Castaneda.
And my name is Wally Zafari.
And we're real estate agents in the Inland Empire, particularly speaking in Riverside, although we cover the entire Southern California. So now we're going to be your co-hosts of the night. And today we aim to empower you with knowledge on how living trusts can secure your legacy and just provide peace of mind for you and your loved ones. So one quick thing to mention, we're going to have 5 minutes at the end for a Q&A session. So make sure to drop any questions on the chat box here on the Zoom. And then we're also going to be raffling two Visa gift cards. So make sure to stay until the end.
It is our honor to introduce our main speaker for today's seminar on living trusts, like Catalina mentioned. With a wealth of experience and expertise in estate planning, please welcome Sam Price. Sam is certified as a specialist in estate planning, trust, and probate law. He is the managing attorney at Price Law Firm located in Redlands, which focuses on probate, estate planning, trust administration, long-term care planning, and litigation. So without further ado, ladies and gentlemen, the man of the hour, Mr. Sam Price, take it away.
Thank you so much. Thank you all for being here today. I still, I'm 51 years old, but in my head, I'm 27. So there are times when I still even wonder that people would listen to what I have to say, because I still think of myself sometimes almost as a kid. But thank you all for being here today and joining us for this program today. I've had the chance to work with Wally and Catalina on multiple cases, and they've helped a lot of my clients, and hopefully they could be of help to you all as well. Let me take a chance to share my screen, and I will be able to share right there and do that, because I think this makes it look like a, let's see, are you guys seeing which screen? You're seeing this screen, right? Does that one big screen now?
It was.
It was before.
This is one big screen to you.
Yes.
Yes, this is one big screen for us.
Gotcha. Okay, cool. So I want to just talk a little bit about estate planning. I want to make this as relevant as I can to you all. So if there's a time when you have a question for me, you can interrupt me. You can unmute yourself and ask a question, but you can also drop a question in the chat box. So that's a bit about me. I'm just going to say that estate planning is really about putting someone in charge, giving them some instructions and the power to act for you in an emergency without having to go to court. So the things that we're trying to avoid in an estate plan is, number one, we're trying to avoid a conservatorship. A conservatorship is like what Britney Spears had, right? She's alive, but cannot make her own decisions. A conservatorship is a court case that is expensive, you lose your voice, and there's ongoing court supervision. We're also trying to avoid a probate case that you're passing. And again, a probate case that you're passing is expensive and time consuming. Now, probate cases themselves are very expensive. So here is a chart giving you the size of an estate, how much the attorney's fees are for those cases. They're set by California law, how much the executor's fees can be, and the court costs as well for the total cost for different types of estates. So let me take an example of like a $300,000 house with a $200,000 mortgage. There's only $100,000 of equity, but that case is going to have total costs of about $20,000. So on that that estate, that $20,000 is 20% of the net estate. So you can see how probate can get very expensive really fast. So that's something that we certainly want to avoid. Now, we also want to think about how your family dynamics will impact your estate plan, because sometimes we have a married couple with young children. So if something happens to you, do we need to have substitute parents? And who will your young children live with? Who are going to be their substitute parents? And who handles their money? Should that be the same person? Even for myself, my wife and I have a little 7-year-old son, and my sister is going to be the person that will take care of him if anything were to happen to Tiffany and I. Well, if should we have someone else handle his money, because my sister does have 2 sons of her own. And I don't necessarily want to not take care of my nephews, but I don't want my sister necessarily be using my money to take care of her children. I'd rather it go towards my child. So should someone else handle the money to make sure there's that separation there? And do you have any special instructions that you might want to give to someone who's going to care for your children? I know that when Tiffany and I go on date night, she has a 2-page sheet of instructions of what Parker eats, when he goes to bed, emergency phone numbers to call. So she has that 2-page list of instructions of what to do just to take care of him. Do you need to leave these instructions? And by the way, that list of instructions only reduces to 1 page when she leaves Parker with me. So, maybe you might have some special instructions you want to give as well. Then we have that situation with blended families. So a blended family is a special type of family dynamic where you might remember that TV show, The Brady Bunch, where the dad had 3 sons, the mom had 3 daughters, but they had no children together. Well, stepchildren do not inherit in an estate. So if you don't have an estate plan in place, how will you treat your children and your stepchildren fairly? What options are available to make sure that your children inherit and your stepchildren also inherit, and what's best for you and your family? Then we have that really awkward conversation sometimes that I have with my clients. And after you're gone, will your spouse remarry? Now, you trust your spouse, but do you necessarily trust your spouse's future spouse, your replacement? And you don't want your money to necessarily go to a new spouse. And is your spouse in a position, even if they don't remarry, to be victimized by someone? And do you want some protections to ensure that your children will inherit? I'll tell you that I have a client, he was in his mid-80s, and his wife passed away. Well, he had been married over 50 years to the same person. And when she passed away, he found himself newly single. And he actually wanted some protections put in place so that younger women wouldn't come around and try to add themselves to bank accounts and make lavish gifts to them. So we actually did do some planning for him. And so that he would have some protections in place, because during COVID, he actually did have a woman come around. And, he's in his mid-80s, he lived in Palm Desert. And he had some younger women come around. And by younger, I mean they were in their 60s. But that's still 20 years younger than him. And so he actually did have a woman come into his life and move in with him. So he's happy that he kind of put some funds aside, protected so that he couldn't be victimized. So what I do with estate planning is this is our process. We guide you to avoid a disaster and gain peace of mind. What I need to do to draft an estate plan is I need to understand your family dynamics, what are your assets, and I need to understand what are your goals and wishes so that I can properly design a plan for you. So this is our process for creating an estate plan. And it starts with a questionnaire. You complete a questionnaire before the consultation, and it goes over your family dynamics, your assets, and what you want your estate plan to do for you and your family. Then we have a conversation about your goals and wishes. Are you concerned about being incapacitated or long-term care costs? Who do you want to provide for in your estate plan? Who do you need to protect? We know who you want to receive your money, but do you have to protect them? And we'll go into that in a little bit. And do you need to avoid any taxes? So the design meeting that we go over, it's kind of like coming to the optometrist, right? They put that machine in front of your face and they say, does this look better or does that look better? Do you like number 1 or do you like number 2? I look at issues that I might spot in your estate plan and I offer options, because my job is to look into the future as an estate planner and think about what could happen into the future. Then I talk to you about, does that matter to you, and what are the options to deal with it? And I kind of go over the pros and cons, but really only you're going to be able to know what's best for you and your family so that you can decide how to design your estate plan. Once we've designed your estate plan, then we go and we draft all the documents. according to your wishes, and we draft each estate plan from scratch for what you want done. Then we have a signing meeting at our office where we explain your estate plan, we verify all the information is correct, and then you sign your estate plan, putting that into motion. Now, after you've signed up your estate plan, I have to say that a trust is a lot like a bucket. If you want to carry something in a bucket, you have to place it inside the bucket. So that's where asset alignment comes in place, because we have to transfer your home to the trust and put it in the trust bucket. We do that with a deed, and we transfer your home to the trust so that you will control it as trustee of your trust. We're going to transfer all of your tangible personal property, your stuff, to the trust, and you're going to go to your bank or brokerage firm to transfer your financial accounts to the trust. And that way, last thing we would be doing is aligning your retirement accounts. There's a few things that we never put into a trust. 4 things, actually. One is retirement accounts. Also, we don't put in life insurance or annuities or vehicles, because the California Vehicle Code makes it really easy to transfer a vehicle without having to go through probate. So those are the 4 things that we do not put into the trust, but they all need to have a beneficiary named on those financial accounts. Then you go into our client care program after we've aligned your assets. And we offer ongoing support and maintenance, and we're here for you when you need us. We offer free phone calls to answer your questions, and we give special notices of legal changes, and we offer seminars on those changes. And we give a free checkup meeting every 3 years. We do ask that you kind of look over your estate planning documents once every year when you do your taxes, just to make sure it's in alignment with your wishes. We offer free trustee trainings to know what to do in an emergency. And your first meeting with your trustee upon your disability or passing is free on us. Because that's where the biggest downfall of estate plans comes in, because we want to make sure that your estate plan will be properly maintained and serviced, because this is the biggest area where other trust plans fail with other law firms that I see. Because over time, things are going to change. We talked about the things that might change are your family dynamics, your assets, and what your goals or wishes are, because your family is going to change over time with births, deaths, and divorces and marriages. Your assets are going to change. You might sell one house and buy another house and upgrade or downgrade or size up or downsize. Your goals and wishes might change. You know, I know that especially with my own mother, after she had grandchildren, I even heard her say once, "You love your grandchildren more than your own." And I'm like, "Mom, I can hear you." And so your goals and wishes might change as your family develops, and you might want to make a gift originally to your children, maybe later on to your grandchildren. And so those goals and wishes might change as well. So regular checkups for your estate plan must become a habit. Again, we recommend at least every 3 years you check in with us. Now, we also want to avoid an estate planning disaster. And so we, as most people, in my experience with my clients, is that we want to give money to our bloodline. We want our money and our inheritance to go to us while we're alive. So if something happens to me, I want it to go to Tiffany, my wife. And especially if we're incapacitated, I want to be able to have that money available to me to take care of me. Now, if something happens to me, give it to Tiffany. If something happens to both Tiffany and I, to our children, and then our grandchildren. But most people do not want their money to go to pay government or taxes unnecessarily. Everyone will pay their fair share of taxes, but not more than you have to. People don't want to pay probate court costs, and they don't want to have money go to their son-in-law or daughter-in-law or your children's creditors. So we want to make sure that we want to know who we want to provide for, but we also want to protect our loved ones from losing their inheritance. So let's go over a few scenarios. Really, your inheritance is like a big pile of cash. Most people think that the only option is to give money directly and outright to their loved ones. When I'm gone, give everything to the kids. Well, The problem with direct and outright distribution is that you lose control after you give them the money. They may spend it on stupid stuff. And believe me, there's a lot of stupid stuff to spend on an inheritance. It's why many lottery winners go bankrupt within 3 years of winning the lottery, because it's a huge pile of cash that you didn't earn. So you don't have the value of the money that you just inherited. So many people spend it wildly or on stupid stuff. Your son-in-law or daughter-in-law may get it. And here's what might happen. Your daughter receives the inheritance after you're gone, and her husband says, "Hey, honey, did you receive the inheritance money from your parents?" And she says, "Yes." And he says, "Okay, well, I looked in our joint bank account and I didn't see a deposit. Do you think the bank made a mistake?" And that's the most awkward conversation that your daughter can ever have with her husband. And it's because she can't say, "Hey, no, dummy, my parents left that money to me so that I could have it, not so you can go buy a dirt bike and remodel the kitchen and go improve your man cave." So if your son-in-law or daughter-in-law can get access to it because it's in a joint bank account with your son or daughter, they can have access to the money and they can spend it, because it may not necessarily be your kid that might spend the money on stupid stuff. It might be their spouse. But what if you could have protected them? Let's kind of take a look at some scenarios. So I have our estate planning couple, husband and wife. They have a son named David, and David is smart. He has a successful career, but he's got a high maintenance wife, and he's susceptible to lawsuits from his business. If our estate planning clients pass away and they give the money directly to their son David, that money can go to the daughter-in-law, and then now she can have the money if it's in that joint bank account. So there's ways to protect against that. He could also be susceptible to lawsuits, and that money be taken from him. So we also can protect against that. Let's go through another scenario. We have our husband and wife, married couple. They have a young son named Jeff, and he's never really handled money before. And it might be a son or grandson. If our estate planning couple pass away, then that money is given directly to Jeff. Now he can get those funds and he can go and spend it on credit card debt, cars, and vacations, taking his friends on vacation with them, because he's young, right? None of his other friends have any money. So if he wants to go somewhere with them, he's got to go take them too. So he could lose his inheritance when he could have been set up for life by him go out and spend it on stupid stuff. And then that money could be gone. Now, here's a scenario that a lot of people don't think about. We kind of talked about the blended family from the standpoint of that TV show, The Brady Bunch, where the dad had 3 sons and the wife had 3 daughters, but no children together. That's a blended family. But even if we have a traditional family, this is how this could creep in. So this is, will your grandkids get the money? Our estate planning couple, husband and wife, have a daughter named Jeannie. Jeannie's married and she has young children. And Jeannie is married to their son-in-law. And they have a granddaughter and a grandson. They have 2 grandchildren. Now, if our estate planning couple pass away and they give all the money to their daughter, Jenny, outright and directly, if something happens to Jenny afterwards, she passes away. She's already received the money, right? If she put that money in a joint bank account, maybe the son-in-law didn't spend it. Maybe they just had it in a joint bank account. But if they did, he gets all the money. So if he has all the money, he might even be the father of their grandchildren. But is he still at an age where he can remarry? And if he has a new wife, then could that money, if he passes away, go to the new wife and not go to the grandkids? Is this a scenario that's a possibility? Yeah, that is something that could happen. So the way to fix this is to have asset protection trusts for your loved ones. Instead of giving the money to them directly and outright, what we do is we keep the funds held in a protective subtrust after you're gone for your beneficiaries. They're going to have a use and benefit trust that in a bloodline that will allow them you to give the money to the right people at the right time and to keep the wrong people out. Your beneficiary, your loved one, will have the access to the money for their needs when they need it. The sub-trust can pay bills for them. So instead of giving them money directly to pay their mortgage, we straight from the trust bank account, we have an electronic payment to the mortgage company. We pay their utilities, their things like the health care premiums, education costs. We could pay any of their costs for them. We just don't give the money directly to them. And it could save them from wasting it. Now, if they need some money to start a business or buy a house or something important, yes, of course, they could have that money. If they needed to go on a little vacation every once in a while, of course, that would be fine. But to go on lavish vacations, to buy a yacht, no. These are things that the trustee can say no to and control that spending. So what these protections would look like is that our estate planning couple have 3 children, David, Jeff, and Jenny. For David, we would create an asset protection trust that would better protect David from his daughter-in-law, from the daughter-in-law spending the money, or from lawsuits. Their young son, Jeff, is better protected from spending the money recklessly or for creditors or from bankruptcy. And Jenny is better protected with the divorce protection trust that keeps her assets separate from her spouse, though he can't spend it. Or if she's gone, the money in the trust is directed to go to the grandkids to make sure that they receive their inheritance. And a son-in-law would not be a part of the bloodline trust. Now, that's the protections we could provide to your loved ones after you're gone. So the other thing that we can do in an estate plan is we can do some asset protection for your home. And this can protect up to $600,000 of the equity of your house. Now, everyone in California gets what's called an automatic homestead. The automatic homestead protects you if you are forced to sell your home. And I say up to $600,000 of equity. So that's the net of the mortgage. But the amount of the protection is based upon the county in which you live and what is the median home price from the prior year in the county that you live in. So up to $600,000. Now, a declared homestead does something extra for you. You still get the benefits of the automatic homestead, but in order to get this, you have to actually record a homestead declaration with the county recorder. You are protected if you are forced to sell your home, and you are protected if you voluntarily sell your home. So that's what a declared homestead does for you, that the automatic homestead does for you. The automatic homestead only helps you if you're forced to sell your home, not if you sell your home. So long as you reinvest the proceeds of the sale of your house into your next primary residence, it will stay protected from your creditors. And a lot of creditors I'm talking about are judgment creditors. You know, you are out driving one day, you hit a pedestrian in a crosswalk, your car insurance is going to protect you up to the policy limits if you're at fault, but you're on the hook for the rest. So if there is an award greater than the policy limits, you could be on the hook for that judgment, and that judgment could be a lien against your house. And that's the type of asset protection we can provide with the declared homestead if we record it prior to you having the liability. Then the other thing we can do in the estate plan is avoiding capital gains tax. So when you pass away, there is a step up in basis to the fair market value of the assets in an estate. And so when you have a married couple, if you hold your house as husband and wife as joint tenants, then the surviving spouse gets a step up in basis of the deceased spouse's half. So the surviving spouse already owned half the property, their basis in their half stays the same, but the deceased spouse's basis increases. So that is the basis becomes the half that the surviving spouse owned plus a fair market value of the half that the deceased spouse gave to the surviving spouse. It's very different if you pass away when you own property as husband and wife as community property or community property with right of survivorship. In California, we have a community property state where each spouse is considered to own half of the community. So it's an undivided half. So when the community terminates at the death of one of the spouses, the entire property goes to the surviving spouse. So the big benefit of being in a community property state is that the surviving spouse gets a full step up in basis to fair market value as of the date of death for the entire value of the property. So that's a huge benefit. So a lot of times what we're doing is we're taking clients who purchase their property as husband and wife as joint tenants, and we are swapping them to a deed where they are husband and wife as community property with right of survivorship. After that, we're transferred to the trust. So this offers a huge tax benefit by avoiding capital gains tax. So here's an example. I just want to kind of explain that a little bit. So if during your lifetime you buy a house for $300,000 and it increases to value to $900,000, your tax basis in that house is $300,000, and if you sell it for $900,000, that's what it's worth. You're going to gain $600,000. Now, if during your lifetime you say, you know what, I'm going to give this gift to my child, I'm just going to transfer this house to my child, that's a lifetime gift. If you bought it for $300,000 and it's worth $900,000, the tax basis to your child is $300,000, because that transferred basis, that gift of the property during your lifetime, transfers the basis in the property of $300,000. If you sell it for $900,000, you're still going to have a $600,000 gain. Now, the difference is if you give the house as an inheritance, it's a gift at death. That's what inheritance is. If it's that same house that you bought for $300,000, it's worth $900,000. The basis to your children at your passing is $900,000. When you sell it for $900,000, there's zero gain. So that's the big benefit of getting a step up in basis. This is for individuals. Let's talk about a married couple. When you have a married couple and a surviving spouse. So if one of the C spouse passes away, same numbers, right? During the joint lifetime, if we have a $300,000 house we bought, it's now worth $900,000. The tax basis for the husband and the wife in their half of the property is each $150,000. When they sell it for $900,000, there's $600,000 of gain. Now, if the property is held as joint tenants and the husband dies, if that same house that was purchased for $300,000 is now worth $900,000, the husband's half of the property, $450,000, gets a step up in basis. But as joint tenants, the wife already owned half, so her basis and her half is $150,000. So when you have a sales price of $900,000, the gain is still $300,000. Contrast that with the husband and wife owning that property as community property with right of survivorship. When the husband dies, the purchase price of $300,000 and the fair market value of $900,000, the entire community property goes to the surviving spouse. So the wife gets a tax basis of $900,000, and since it's worth $900,000, she sells it for $900,000. She has zero gain. So that's a way that we can avoid the capital gains tax when we transfer a property. And really, an estate plan really enjoys the biggest benefit of all is getting that peace of mind, knowing that your loved ones are protected. Hopefully, I've gone over and given you an understanding of the difference between estate planners and living trust plans, but really, where do you go from here? So I wanted to give pricing for our foundational estate planning for married couples. If our essentials plan avoids probate, it avoids conservatorship, it gives outright distribution, so there's not those same protections for your loved ones, but you can give to whoever you want. That is $3,900. And our family and money protection plan avoids probate, avoids conservatorship, you give to who you want. But this also adds the asset protection trusts for your loved ones after you're gone to avoid divorce, death, disability, bankruptcy. That is $4,900. Then our legacy plan does all this, everything that the other plans do. It avoids conservatorships and probate. You give to who you want. It's going to give those asset protection trusts for your children after you're gone. And also it's going to avoid capital gains tax. And it's also going to give asset protection for your home. That is $5,900. If you have any additional deeds we have to do, we charge $650 for preparing and recording each one of those. Or if you have any business entities we have to transfer to the trust, we charge an additional $500 each for those. I'll leave that up for just a moment so you can see that if you want to take a picture with your phone. I've also provided all the slides to Catalina and Wally so that they have those if you guys needed that as well. I am offering a free consultation for anyone who would like to meet with us to talk about estate planning. I'm offering $500 off the plan of your choice if you book an appointment by May 15th. There is a QR code. If you use your phone to link to the QR code, you'll be able to book directly an appointment with our office. Brandy at my office does our initial consultations, and she'll be able to go over the plans with you. And she knows that we're having this conversation today. So I want to, at this time, and this is a picture of Tiffany, Parker, and I in Sacramento. I was amazed. We went to Sacramento and we saw this river, and there are boats riding up and down the river. And I thought, in Southern California, a river is dry most of the year. There's no water in it. And I'm amazed that there's a river that anybody can sail a boat up and down. But there's a riverboat right in Old Town Sacramento, and that's where this picture was taken last month. So I'm going to take my slides down, and I'm going to stop sharing so that I can have some time to answer any questions that any of you might have about estate planning or anything else related.
Sam, there's actually one question that
Yeah.
I did have for you, and it just came to mind. We have so many of our clients that live outside of California, and I'm sure that things work completely different out there. So just briefly, what can you tell us about, the folks that are out of state?
Great
How they can benefit from this? Mm-hmm.
Great question. So for estate planning is going to, the law of estate planning goes by where you live. And the law says your domicile. So your domicile is not only where is your primary residence, but where do you intend to be your primary residence? Most people, it's pretty cut and dry. What is your primary residence? Where is your domicile? It's where you live. But for some people that might have more than one home, they sometimes they split time between different states. So that might be a question of where their domicile is. But really, I would recommend that I'm only licensed in California. So my license stops at the border. So I only help people domiciled and who live in California. So I would suggest if you're in another state and your domicile is in another state, that you seek out an estate planning attorney in that state.
Okay.
Another thing that comes up sometimes is if they're, I'll tell you real quick, Wally. The other thing that comes up sometimes is if you have assets in another country. So sometimes people might have a home in another country. Tiffany, my wife is from England, so she still has a flat in London. Well, when I started talking to her estate planning attorney in London about a trust, they're like, "Oh, you Yanks, you use trust. We don't use trust here. We make a will," and it's completely different country to country. I mean, the law of trusts and wills comes from England, but they don't use them themselves in estate planning. So it's really, really different when you deal with different countries. So if you have a real estate in another country, you do have to separately also go to another attorney in that country to do an estate plan there.
So
Sorry,
potentially,
Paul, I didn't mean to cut you off.
Oh, no, not at all. I thought I heard somebody, one of the participants, about to ask a question. So just in case they were, I go for it. I think Paco just sent a message on that.
Yeah. So Paco's asking, okay, what happens if the person that received money from parents and they don't have kids, they pass away? What happens to the money they have received from their parents that have also passed away?
So good question. It depends. So let's say parents and then let's say son and daughter. Okay, so we have the parents and then they both pass away. The husband and wife pass away, and then they give everything to their son and daughter. Now, if son doesn't have children, he's received as half of the inheritance. If you give it to him outright and directly, California law takes over. So if he doesn't leave children, his spouse would be entitled to half, and his sister would be entitled to half. because in our scenario, both parents have passed away and there was a son and a daughter. So sister half, his spouse half, if he had a spouse. If he had no spouse, then all to his sister. Because in that scenario, you're saying the son had no children. Now, if, again, husband and wife give to their son and daughter, if the daughter received half directly and outright, and she had children, her children receive her half, her husband may also be entitled to either 1/3 or 1/2, depending on how many children she had. So that's the general rule under California law. So that's kind of why if you want to leave things in trust, different things happen. So ordinarily we would say, hey, let's leave this in trust rather than giving everything directly and outright to children. Why don't we leave this in a asset protection trust for son and daughter after the parents are gone? Then if son passes away and it's held in trust, your trust will provide what will happen to those funds. We would normally, even if a son doesn't have children now, we always assume someone could have children in the future or that they might adopt. And so we would normally say, okay, to son's children, if he has any. If he doesn't have any, then to sister. That would bypass and leave out a daughter-in-law. So we keep assets in our bloodline. Now, that's if you leave the funds in trust. So the scenario is different whether or not you want to control the funds from the grave, leaving them in an asset protection trust after you're gone. You can direct where the funds go. And that's why I'm talking about, many people want to leave stuff to their bloodline. I get it. I'm a son-in-law, right? I get it. I love my mother-in-law. I love my father-in-law. I'm sure they love me too, but I don't think they want to provide for me. They want to provide for my wife and then our son.
And their grandkid. Yeah.
Right.
Yeah. So.
Yeah, that makes sense.
Good question. Yeah, very good question.
Yeah.
So the asset protection plan could also work for, let's say, if the beneficiary is not of age.
Minors. Yeah, well, both plans. Good question. So let's we have minor children, they're under 18. With direct and outright distribution, we can't give money to a minor. So we're gonna always have, they can't open a bank account, they don't have a driver's license, they can't sign contracts, open a bank account. So what we do is we hold the funds in trust until 18 if it's outright distribution, or if it's held in trust, we could hold it up in trust for up to their lifetime. So it depends upon which plan you want. If you want the essentials plan, at 18, they get it all. And what happens when an 18-year-old gets a ton of money? They buy a fast car every time.
Yeah.
Yeah.
I was just going to say that. Here was one.
Yeah. You get two, right? I mean, you're getting a bunch of money, right? You're 18, but you should be spending that money for school, right? I mean, 18 to 24 is kind of that time period where you're an adult, but not really, right? You're still usually needing your parents. You're probably still in your education time and just starting your career and your adult life. You're adult, but not really. So you kind of still need someone to kind of guide you. And so that's why we oftentimes will leave funds in trust. I mean, another family dynamic that we didn't talk about is kind of the family dynamic where you have older children, then all of a sudden you have oh, surprise, we're pregnant. And your kids are in their early 20s, and then you got another kid that's 8 years old. And so that family dynamic is really different because these older children already receive the benefit of having their parents help them. But if your parents pass away and you're a minor, you want to be able to have that younger child not necessarily receive an equal inheritance, but really to get that same help through that crucial young adult age of kind of 18 to 24, where you're still really looking for help from your parents. So sometimes we want to have a different solution for that. I often have a conversation about a client about having a common pot trust where we don't really distribute until the youngest child reaches around 24. So that's something that is also an option for another different type of family dynamic. Yeah.
Let's see if anybody wants to ask any other questions.
Hi, it's Jennifer.
Hi, Jennifer.
Hi, I just have a question. What happens if I forget to put something into the trust? So for example, I go to my bank and I decide to transfer some of my savings into a CD, but I forget to put it in the name of the trust.
Common issue. And let me see. I think I took it downstairs. I had my really cool visual aids, right? So I think I took that downstairs, but good question. So what you're describing is we had assets in the trust bucket, but we left something out of the bucket. So a will and a trust work together. We're going to create a will that this will is called a pour over will, because if you left something out of the trust bucket, we're going to pour it back into the trust bucket. So when we initially look at your estate plan, we're going to line your assets according to what your wishes are. So we're going to have everything in the trust bucket. But if you later on, one day you say, you know, I'm tired of this bank. There's always a line. There's not very good customer service. I'm going to switch banks. And then you switch to a new bank, and that new bank, you forget to title it in your name as trustee of the trust. Now that's outside of the trust bucket. So your will scoops it up and pours it into the trust. Unfortunately, that might require a probate action, depending on how much money is in the bank account. Or if it's real estate always requires a court order to transfer or to put someone in charge of it. So we don't want to have to rely on the pour over will, but that is a backup just in case you left something outside the trust bucket.
Thank you.
Good question, Jennifer.
Okay, let's see if somebody else has
Maybe
a
in the
question.
chat box.
I can't be that good at answering questions. There must be some more.
Nah. No, nothing else in the chat box. So
It's Jennifer. I have another question.
Of course.
There you
Yeah.
go.
There we go. Yeah.
Yeah, and forgive my ignorance on this, but do you also deal with estate planning in regards to durable power of attorney, things like that, or is that something that we would do separately?
No, that's included. So I normally don't talk about documents because it's paperwork, right? But let's kind of dig a little deeper. There are two different types of conservatorship that we're trying to avoid. So one is called a conservatorship of the person, where someone makes personal decisions for you. So a lot of those personal decisions have to do with your medical decisions. So what we're going to create to avoid a conservatorship of the person is an advanced healthcare directive that allows someone to make medical decisions for you. So you're going to nominate an agent that will make those decisions. You're going to give them some instructions of what you want for your medical care. Then we're also going to make a HIPAA waiver, because the HIPAA laws require that the hospitals and doctors keep your private medical information confidential. So we want to be able to give permission to the doctors and hospitals to let your agent in on what your healthcare needs are. The other thing that we're going to do is we're going to avoid a conservatorship of the estate, which is the court proceeding that allows someone to handle your money. So to allow someone else to handle your money, what we're going to do is we're going to create a durable power of attorney with springing powers. Durable, meaning that it survives your incapacity. A general power of attorney terminates when you become incapacitated. Incapacitated meaning you cannot make your own, you're not able to make your own decisions, but you're alive. Springing power of attorney means that it springs into action once you become incapacitated as determined by your doctor. So we don't want this thing active all the time, because someone could literally go into your bank and withdraw all the money with the power of an attorney. So you want to be sure you have the right agent in place, and you want to make sure that it's springing, meaning that it only springs into action once your doctor determines you're incapacitated, because you could not be present when someone walks into your bank and uses that power of attorney. Or they could use a power of attorney to sell your house. They could do all kinds of things with it. So we want to make sure that's someone you trust, and we want to make sure it only happens once you become incapacitated, because it could be happening without your presence. That's the opposite of what we do with the advanced healthcare directive. Your agent's powers will become immediately active, because I don't want to have to wait for a doctor's note to say that you're incapacitated. If we need to take care of your healthcare, we need to do it immediately because it's urgent. But if it's your healthcare, you're always present. It can never happen without your presence, right? Because it's about your healthcare. So
Right.
I make the advanced healthcare directive active presently. So it's immediately active. But those are the documents that we're using to avoid a conservatorship. The trust itself avoids a conservatorship too, because you're going to name someone to take over your trust, a successor trustee that will take that over and be able to manage your finances. So that's also a mechanism. There's multiple layers of backstops that we have to make sure that we avoid a conservatorship. But just in case you needed one, we still nominate a a successor, a conservator, if you had to have one. So those are the kind of some of the things that we wanted to put in place, and those are some of the documents we do to avoid conservatorship. The will and the trust avoid probate. I hope that answers your question, Jennifer.
Yes, it does. Thank you.
Cool, good.
Very good. All right. Let's see if nobody else has any questions. I think that's it. So I like Sam said, we're going to send everybody an email with a copy of the slides because they're super valuable. And then also a copy of this recording so that, you know, those who didn't make it, unfortunately, we had a lot of people who registered for it. And I understand, you know, some things happen and it's close to dinner time and there's so many things going on at this time. So we wanted to make sure that everybody gets a copy of the recording and Sam's information so that if you didn't make it and you have questions, you can contact him, his office, and set up a consultation, a 15-minute consultation. Actually, we have one more question.
My mom and I are on the house. My brother is on the deed. What type of trust do we need to get split the house among siblings? My mom and I are on the house. My brother is on the deed. I'm sorry, maybe I don't follow the title to the property.
Mom and I are on the house.
So can you hear me?
Yeah.
Yes, Yolanda, go ahead.
Okay. Yeah, sorry. So yeah, and me and my mom are on the house. And hi, Catalina. This is Yolanda.
Hi.
Hi. And you know my situation, but I added my brother to the deed, and I know we're gonna probably fight about it, and to avoid all that and probate and everything. People are telling me to put the house on a trust. Is that something I need to do, or just would a will be sufficient? Or because my mom, she's still alive, thank God, she's 90. And pretty much what she wants to do is kind of like split the, um, sell the house and split it if we get to that.
So just to be sure that I understand, are you, your mother, and your brother all on title as joint tenants?
I think that's what we did.
Okay. Yeah, kind of the issue with joint tenancy is we talked about that issue of transferring an interest in the house during lifetime, that you get a transferred basis. So that's one issue. And the other issue is if you pass away in the wrong order. So if your brother passes away, would he want his share to go to you and your mother, or would he want to go to his children? Same thing for you, right? So, I mean, if you don't die in the right order, if you have a simultaneous passing, then it's the surviving joint tenant that receives the property, not necessarily your heirs or your children. And so a lot of times I see families add people to the deed to the house in order to avoid probate. That's not the ideal way to do that. Normally the best way is to have a trust, but if all three of you are on title now, but
we have other siblings, like we have other 5 other siblings.
Right. And so ordinarily if it's your mother's home, then she would be creating a trust to give it to her children how she wants to, in the way that she wants to. And you and your brother would not be on title, because a trust will only control her share of the house. So she would need, if she wants to have control of the entire house, maybe we do a transfer back to her. Do all three of you live at the home?
Yeah.
So yeah, then the other thing is, did you all file a homeowner's exemption for the house?
Well, yeah, because it was
assessment.
originally under mine and my mom's, which is homestead, I guess, homeowner's exemption.
Yeah. That's good, because you should, because there are tax benefits to having that homeowner's exemption, and then as well for property taxes. And then if you're going to do some transfers around, we got to make sure that those transfers don't trigger a reassessment for property tax purposes. So so there are some things that you need to take a look at before you start transferring things around.
Okay, so where do you think I should start? By my mom doing the trust herself, or?
Yeah, because are you and your brother going to transfer your interest back to her? Is that the plan?
Yeah.
Yeah, so
Mm.
yeah, so she would have a trust and we would take care of the deeds to make the title right to her. And we would also be able to file the documents to make sure that the property doesn't get reassessed for property tax purposes, so long as you've all have a proper homeowner's exemption filed with the county assessor.
Okay, and say he doesn't agree with that.
That's a
Could she still?
possibility.
Mhm.
Yeah,
He
no,
got his
that's
inheritance early.
right. What do you mean need the property back? Yeah, that's
Yeah.
a problem. You're right. That's a problem. That's the problem with adding people to a deed. And so
Yeah.
once he's on it, he's on it. He needs to
Mhm.
agree to transfer
And
back.
everything.
Yeah,
Mm.
yeah.
Okay. Well, all right.
Let's see, Paco, you got a follow-up question? Oh, sorry.
Yeah.
Did I answer your question, Yolanda?
Yeah, pretty much I'm screwed. But yeah, I can't do
Yeah.
anything.
Yeah, let's see. Paco,
Yeah.
you said, if I have several properties and 4 kids, if I pass 10 years later after giving my younger daughter a property, what happens to that property? Is my daughter responsible for any taxes? Yeah. So, I mean, the taxes that people are usually talking about are property taxes. So there's a possibility that the property will be reassessed for property tax purposes, that the property taxes will be higher when she inherits a property. And the second type of taxes people are usually talking about are income taxes in the form of capital gains taxes. So yes, if she later sells the property, then she would be responsible for any capital gains. And again, really remember there's two ways to give her a property. Either she receives the property held in the trust, or she receives it directly and outright and she owns the house. So those are two different ways to give her a property. I mean, if the later wants to sell one property and buy another one, if it's in the trust, she can do that. Or if she receives it directly and outright, she can do that too, but you really lose control over what happens when you distribute out that house. Does that answer your question, Paco?
Mhm.
I don't think he's on the chat. Did he respond?
Yeah, he's there.
Oh, okay. Go.
All right, very good. Well,
Yes.
oh,
Cool.
he said yes.
Thumbs up. I got a thumbs up. Nice.
Raise your hand.
Of course.
Perfect, very good. Well, we want to be mindful of everyone's time. So I know that most likely everybody wants to head out to family gatherings and dinners. So we are going to do this quick raffle before we head out. Let's see, how does this work? Thanks to technology, there's ways to actually do a raffle where, look at that, people will see who gets to be the winner.
How
So
fun is that?
I know, right? So we actually have two winners today, and let's just do it. It'll be quick. And then that can be put towards your if they decide to work with you to your fee.
Nice.
Linda Chan. So awesome. We're gonna contact Linda
Congratulations.
later. And then one more.
Linda again?
No, she was removed. Oh, look at that. Jennifer Venner. She just
Ah,
asked
nice.
those questions.
Winner.
Very good. All right, sounds great. Well, thank you so much, everybody who made it today. Thank you, Sam, for all your time. We were super excited to get all this information that you were going to share with us, because it's sad to hear so many of our clients that go through probate. The common sentence that they say is, "I don't wish this upon my worst enemy." And we've heard it so many times that it just keeps resonating with us, and we're like, no, we just have to do something to remind and nudge our clients so that they understand how important this is to get their estate planning going, and just avoid any headaches for themselves and their kids. So we really wanted to thank you for your time, and yeah, do you have anything else to say?
No, you know what? Touching back on clients, and that we specialize a lot of our real estate business on probates, and we have so many clients who, now that they've gone through the probate process or finishing up, we encourage them moving forward for their families even to look into make sure that their kids never have to go through what they've just gone through. So,
As a matter of fact, Jennifer, you know, she knows what she's talking about. She went through it, so that's why she's asking those questions. And we love that.
we actually have one participant, Marcy Frampton, actually joined this webinar, and she actually just signed up with Sam's team a few days ago, Mr. Price, right?
Yep. We just got her appointed last week.
Yeah. So she joined on the seminar too. So she's going through probate currently with her mother's estate, so she understands that she doesn't want her kids to go through what she's going through. So we value it a lot, and we think it was important for all of our current past clients to also learn about the importance of this.
Yeah.
Thank you.
Thank you so much for your time.
And I always love working with Wally and Catalina. You guys always do a great job, so I appreciate you and thank you.
Thank you.
All right.
Thank you.
Well, have a great evening, everybody. And then we're here, whatever you need. Like I said, we are going to send all of your all of the slides, Sam, to all the people that register. So make sure to contact Sam's office with any questions.
And the recording of this.
And the recording.
This
Yeah.
web.
So thank you all for your time. Have a great
Thank you,
evening.
guys.
Bye, everybody.
Have a good evening.
Bye.